against unreasonable searches and seizures. Ellipses, it tails on, there's more rights in there. But that's the United States Constitution, the Fourth Amendment. And then and the law is also, quote, it is well settled that the Fourth Amendment's protection, this is quant, by the way, this comes from the case they cite. It is well settled that the Fourth Amendment's protection extends beyond the sphere of criminal investigations. Again, Quan was a government employer seeking government employees' phone records. Say, Fourth Amendment applies there too, not just when the police want to go search a house. It's the government, and that's what the Fourth Amendment is protecting us from, right? So that's their case. Now, the Supreme Court has held that this protection extends to searches and seizures not only by law enforcement. This is what I just said. It's a different Florida Supreme Court case. They didn't just say that for the United States Supreme Court case. They didn't just say that once. They said it twice. In O'Connor versus Ortega in 1987. The Supreme Court has held that this protection extends to searches and seizures not only by law enforcement authorities, but also by government officials who conduct various civil activities, like here. And by the way, I cited one case. There's a string cite. There's others that have said that too. In discussing the employer-employee issues, this court, the one this opinion they're asking you to rely upon, the court strongly suggested that outside the employee-employer context, the public would have a reasonable expectation of privacy in cell phone and text messages. Then it says, and they did that in explaining why that doesn't apply in the context of why that wouldn't apply to a government-issued cell phone, right? That's not what we have here, a personal cell phone for which he pays. And it elaborated, cell phone and text message communications are so pervasive that some persons may consider them to be essential means or necessary instruments for self-expression, even self-identification. That might strengthen the case for an expectation of privacy in the employee-employer context. On the other hand, the court says, in explaining why it was okay, why it was not an unreasonable search to go after the government-issued cell phone. On the other hand, the ubiquity of those devices has made them generally affordable, so one could counter that employees who need cell phones or similar devices for personal matters can purchase and pay for their own. In other words, that's not what we're saying the government can come get. We're saying we can get your government phone because you got your own phone. It's the exact opposite of what we're trying to tell you, in other words. And more about that real quick. Consistent with the court's statement in Quan, other courts have found that individuals have a reasonable expectation of privacy in their cell phones, not their employer cell phones, but in their cell phones, and the information stored therein, including text messages. That's United States versus ZAVALA. That's the Fifth Circuit, 2008. And what that court found was cell phones contain a wealth of private information, including emails, text messages, call histories, address books, and subscriber numbers, end quote. Thus, the defendant, quote, had a reasonable expectation of privacy regarding such information, close quote. Now, I'm going to spare y'all, but I've got the rest of that. There's a bunch of other cases that say the same thing, and this is small print. That, too. This is not just one case saying that. This is axiomatic in terms of constitutional privacy law. So, the bottom line on that order, they asked for his personal cell phone records. He asserted his constitutional objection to that. They cite a case that has no bearing on this whatsoever. And then they fire him for not complying with the order, or at least in part. There were other parts, and I'm only addressing the first part of the notice, obviously. But in terms of Fourth Amendment jurisprudence, what the government needed in order, if it was going to follow up on that, was a warrant. That is not a reasonable warrantless search in light of the cases I just said. So, and again, it applies not just to criminal investigation by law enforcement agencies. That Fourth Amendment standard applies to any time any part of the government wants to get your personal private stuff. Man, this is the United States of America. This is the way that is. And I'm going to get past that, but I hope you all appreciate that is the law. But rather than do that in the face of Mr. Gardner's assertion of his constitutional rights, the county then said, no, we'll just fire you for not complying with the order. Now, in addition to, and this is not the purview of this board, but there are procedural due process violations that need to be addressed if he doesn't get remedy here for administrator. But this actually, if he's fired for that, that is a substantive due process claim that would be included in the single suit. So this is serious stuff, folks. The government can't do that, and then putting aside the civil rights jurisprudence that I just alluded to, because it ain't got nothing to do with this, the county's own code says you can't do it. You can't fire someone for refusing to comply with an unlawful order. They never tested that order. Now, while it's okay for Mr. Smith and the county attorney's office to pass on the lawfulness of an order when asked by somebody in the county government, he is not an adjudicator of that. He's not the judge. He doesn't get to decide that. There is a procedure that the county could have followed. It could have gone to court. Could have sought a warrant, or sought a deck action, or any other number of things. Instead, they said, okay, no, now we're going to fire you for not complying with the order. That's bad. That's improper grounds to fire him for the reasons I just said, and it also is going to cause them a lot bigger problems than they can ever imagine. And that's all I got to say on the unlawful order. Oh wait, the whole idea, tie that off. The whole idea, and they said it. They said it throughout the investigation. After, I'm sorry, I take that back. There's a couple more points I want to make about that. This is all, of course, after the investigation was reopened. Remember, we got the IA report at the conclusion of the investigation that Captain mckinnonc2.flv did. It was, I don't know, it was the 18th or 13th of August. There was but it was attached to the notice of intent. The notice of intent to dismiss is required by Florida law, specifically section 112.533, subparagraph 4, subparagraph A. You flat got to do that, or you're violating procedural due process rights, which have been recognized by the courts. So, one point I want to make about the cell phone records and anything else that came in after Mr. Coffin reopened this investigation on October 25th in response to my October 24th response to his NOI, and I don't know if you guys want to get into this or not, but that for the reasons, actually I did not explain it after the fact, but we contend that that was an unlawful reopening of the investigation. And they did get into this. Mr. Smith testified at length about the matters, why he chose to reopen the investigation. The letter reopening came from Coffin, but Smith testified. It was because of the stuff that Caney said in his very extensive letter. He kept repeating that. The allegations that Caney said, now look, there's Florida law is clear on how you can reopen an investigation. And that is found in section 112.532, subparagraph 6, subparagraph B, which provides in pertinent part. An investigation against a law enforcement officer or correctional officer may be reopened if, and this one was closed, got an IA report, got a notice of intent to dismiss, to which I responded on October 24th. October 25th, Mr. Coffin reopens it, according to Mr. Smith, at his direction. An investigation against a law enforcement officer or correctional officer may be reopened if, 1, significant new evidence has been discovered that is likely to affect the outcome of the investigation. 2, the evidence could not have reasonably been discovered in the normal course of the investigation, or the evidence resulted from the pre-disciplinary response of the officer. And that's what they say they reopened it under. It was reopened, evidence resulted from the pre-disciplinary response of that officer. Now, you go back to my pre-disciplinary response of that officer, the only new allegations in there were against Mr. Coffin. There was no new allegations against my own client. There's nothing in here that lawfully allows them to reopen that already closed investigation. And that was one of the matters we sought to have addressed before the compliance review hearing, which we requested in the December 21st letter that they conveniently declined to have because they didn't want to answer for their own transgressions in the investigation. Instead, they proceeded to fire Mr. Gardner by issuing a notice of dismissal without first issuing the required by Florida law notice of intent to dismiss in advance of the action, stating the grounds, opportunity to respond. They did that the first time, and you know, the notice of intent to dismiss from the first one, it doesn't say anything about phone records. So that's another reason. Not only is it an unlawful order, it's not even supposed to be part of this investigation. It's a part of the unlawfully reopened investigation. Now that is, wait, the final point I wanted to make, started to make last time, is this whole argument about that Mr. Gardner took pictures with his personal phone. I'm not clear whether he did or not. I'm not sure whether he was clear based on his testimony about that. But let's assume he did that. what they're saying is, and they were clear all along, they were investigating his on-duty personal calls with Kara Gittner and Paige Winters, right? On-duty personal calls with his personal cell phone, right? And so now what they're saying, we hadn't heard this before, but now what they're saying is, oh, well, it's a lawful order because of this unrelated issue of he took some pictures years ago in these bathrooms